Hello, good morning, everyone. I think there's still some who are yet to join, but we will begin the class. So last class we learned about contract. We learned about the definition of a contract. We learned about what is an agreement, and we also learned that an agreement that is enforceable in law is a contract. Before that, we learned about what are the elements in a contract. We said it has to have an offer, it has to have an acceptance. That is, an offer must be accepted to be made an agreement, or to constitute an agreement. There has to be an offer and acceptance of that offer to constitute an agreement. Now, for that agreement to be considered as legally valid and to be concretized into a contract, so we said we need legal enforceability. Now, legal enforceability factors also constitute as elements of contract. That is, there is something called as consideration, which we'll be doing today. And then we spoke about, there has to be intention of the parties, legal intention of the parties. For example, contract to sell drugs is not a valid contract, for example. So the intention of the party should be legal in nature. So, or it should be for a legal purpose. So illegal purposes cannot be enforced in law. See, for example, there is an offer to sell drugs, there is acceptance to sell drugs, and then there is a consideration as well. They give something in return, there is some payment, and both the parties are, they have the capacity to contract, they are normal in mind, they are, both are, they have attained the age of majority, whatever. So all the constituent factors are there, but the purpose of the contract is to sell drugs. So anything that is illegal in nature, and the purpose, if it is illegal in nature, it cannot be considered to be a valid contract. So this is just to set the perspective. So therefore, again, I'm repeating as a revision for you, we learned about agreements that would become a contract. And for an agreement to be considered as an agreement, we said there should be offer plus acceptance is an agreement. We learned about the essentials of a valid offer. Then we learned about some case laws. We learned about essential, factors or elements in acceptance. And now we are going towards the third element in the contract, that is the legal enforceability part of it. And for a contract to be considered legally enforceable, it has to have one consideration. Of course, the party should have the capacity to contract, which we'll be doing later on. And then there should be legal intention, which I've already kind of explained to you, but then again, we'll do it in detail later on. For today's class, we are going to learn about consideration, and we are going to see the concept of consideration in the international perspective, because as you know, laws vary from one jurisdiction to another. We all know that. Now, the laws of contract are similar everywhere. However, there are certain concepts which are, different, and it is differently interpreted and, differently used. For example, is a concept of consideration. What is a valid consideration? When it would be considered as a valid consideration, and so on. So there are certain factors that differentiate with respect to the interpretation and implementation in different jurisdictions or in different parts of the world. Let's move on to our slides. So what is this consideration? Now, just going by the slide itself, In the last chapter, we learned that an agreement that is legally enforceable is a contract, as we just discussed some time back. Not every agreement can be regarded as a binding contract. That's what we said last class. All agreements cannot be called as contracts, but all contracts may be agreements. I'm repeating, or rather I'll put it this way. All contracts are agreements, but not all agreements are contracts. So this kind of question can come to you even for exams. I'm repeating again, all agreements are contracts, but all contracts are agreements, but not all agreements are contract. Now, what is the answer for this? Can someone tell me? All agreements cannot be called as contracts.
Yes, it's clear.
Yeah.
This means agreement is more than a contract. There are many other agreements like political, economical, but contract is a smaller set. This means it's a subset of agreement. So contracts can be agreement, but agreements cannot agree. All agreements are not contracts. This means not every agreement is contract, and that's true.
Okay. Now listen carefully. Okay. Thanks, Kasim. Okay. Now listen carefully. Does someone else want to say something? Do you want to comment on this?
Yes, teacher. I want to
yes, please.
Yeah, I want to add a contract enforceable by the law. A contract is enforceable by the law. There is a legal intention to be getting in contract, but agreement is to be only an offer plus acceptance. There is offer plus acceptance. There is no written enforceable by the law. So that's the difference.
Yes, Naima, thank you so much. I'm glad today you spoke. Okay. Okay, now listen, everybody. That's the reason I was teaching you, in the basic form initially. Listen to me carefully. I'm repeating, okay, Kasim and everyone. Again, let me revise it before going through the concept of consideration. We all know, I'm going from the basic, okay? Though we know everything, but still sometimes it might, skip our attention and we may not be able to articulate it. So I'm just repeating. We all know that every day, knowingly or unknowingly, we go through agreements and contracts. For example, even when we board a public transport system, say like a bus or a taxi, you are entering into a kind of a contract. When you are, sorry, there's some construction going on the side. I cannot stop it. It's released by the drilling sound. Okay. So then I was talking about, like, even if you go to a shop, okay, you go to purchase some goods, it is a kind of an agreement and a contract that you are entering into. You're entering into. Now, what is an agreement? Listen carefully. I agree with you, okay, to give my services to you as a teacher. I agree with you. So there is an offer. Say now, you are giving me an offer. Would you teach me? I am accepting that offer. So offer plus acceptance is an agreement. Okay? Offer plus acceptance is an agreement. Now, to this agreement, suppose now, for example, I tell you, yes, Naima or Aisha or Qasim, Issei, Abdirrahman, I say, yes, I'm going to meet you every Tuesday at 8 a.m. And even without informing you, I'm not available for one Tuesday. So probably you might think, okay, maybe she's sick. Something has happened that she's not involved. Okay, forget it. So again, it happens the next Tuesday, again the third Tuesday, and now you are like, your the study program is jeopardized and exams are nearing and you're lost. So now, can you file a case against me? Listen carefully, you're going to answer it. Now, the answer to this is not really, because there is no legal enforceability to this. Because you gave me an offer, I accepted, but there is no legal enforceability to a contract. However, listen carefully. If you prove the jeopardy, the factor of jeopardy, and that you are, and then there is an offer and acceptance, there is a possibility you sue me. But for it to be considered as a contract, legal enforceability is missing. So I said that offer plus acceptance is an agreement. I agree. Now, for this agreement to be legally enforceable, it has to take off. Now the flight is on the ground. Offer plus acceptance. Now it has to take off. To take off, you need legal enforceability. Now, what is the role of this factor of taking off? If any of the parties do not perform their part of contract, or there is a breach of contract, you can catch the neck of the person and sue the person in the court of law. Of course, there is a valid agreement here. Offer plus acceptance is a valid agreement. There is an agreement. It's a smaller part. It's an agreement. No problem. See, normally in the legal world, sometimes we do not always, write when we are drafting something. We do not always say contract. We might call it as a purchase agreement, sales agreement, or just a subcontracting agreement, or we just give the term agreement, because the word actually offer plus acceptance, and then it has certain terms in that which makes it a contract. I mean, practically speaking. But for you to know, once you know what is the concept, like whatever is worded, you already know the answer, practically speaking. Okay, so an offer plus acceptance is an agreement. Now, for that agreement to be legally binding, there are some other factors that is involved there. So an agreement which can be legally enforceable is a contract. Therefore, we say that all contracts may be agreements, because offer plus acceptance is there. The ingredients are there. All contracts are agreements. But all agreements are not contracts. Why? Because enforceability part is missing. So therefore, the simplest definition of a contract is an agreement which is enforceable in law is a contract. Offer, when it is accepted, it becomes an agreement. This agreement, when it is legally enforceable, or it is capable of being enforced in the court of law or legally, it becomes a contract. So of course, the broader picture is you'll have to have offer in a contract, you'll have to have acceptance in the contract, you'll have to have legal enforceability in the contract. 1, 2, 3, legal enforceability. So I am at stage 1, 1 plus 2. Offer acceptance is an agreement. Now this agreement, there has to be legal enforceability. Now, for it to be considered to be legally enforceable, some other elements are in a contract, consideration. Then capacity to contract, that is, the party should not be a minor. There are certain exceptions when a minor's contract may be a contract. There are exceptions to every rule. then a person should be of a sound mind. An insane person cannot, a person who is not normal in mind, sorry, cannot enter into a contract. A child cannot enter into a contract, but again, there are exceptions. And so on. So mental capacity to contract. So this capacity to contract, and the purpose of the contract, intention of the parties to the contract. These are all elements, the other elements, but they come within the ambit of legal enforceability. So simply speaking, 1 + 2, offer acceptance is an agreement. Agreement with legal enforceability factor is a contract. Now, this legal enforceability in brackets, how it can be legally enforced, it has to have a consideration, capacity to contract, intention of the parties to the contract should be, ascertained whether what was the intention in their mind, and the purpose, what is the purpose, it should be for a legal purpose, and so on. So therefore, all contracts are agreements, but not all agreements are contract. Are you understanding me?
Yes.
Okay, thank you. So now let's move on to the next element to prove our legal enforceability part of it. That is consideration. Remember the sentence, it can come for your exams. All contracts are agreements, but not all agreements are contracts. Now, not every agreement can be regarded as binding contract. For an agreement to be binding, it must be capable of being legally enforced. The factor of legal enforceability must be established. It must be proved to bind the parties to a contract. Or I put it like this, the factor of legal enforceability must be evidenced to bind the parties to a contract. So legal enforceability can be established by examining the following elements. Of course, there has to be existence of a valid offer in a contract, valid acceptance, thus constituting a valid agreement. Then it should have the element of consideration. Purpose of the contract must be legitimate. That means legal. It should be legal in nature. I give you an example like contracting for the sale of drugs. It is illegal. International law, it's domestic laws as well as international. It is illegal to deal with drugs. Then parties to the contract must have capacity to contract. I said minor and sound mind. Then consent of the parties must be free. And no one should, you should not be forced to sign a contract. They should, there should be no coercion. We'll study this. Coercion, duress, misrepresentation shouldn't be there. So consent of the parties must be free. Yes, I am willing to enter into a contract, not by force, coercion, intimidation, that is somebody threatening you to sign the contract. So consent must be free. Okay, we'll study that later on. So in this chapter, let us study or concentrate on the concept of consideration. Consideration is a fundamental part of a contract in the business world. Why we are saying it's fundamental? Because it operates on the principle of quid pro quo, Q-U-I-D, quid. You'll see it in the other slides, don't worry. P-R-O, pro, quo, Q-U-O. It's a Latin maxim. That means something in return. If I give you this, you give me something else in return. So quid pro quo. So it revolves around the principle of quid pro quo. So what I said was, it is a fundamental part of a contract to be legally enforceable. There has to be a valid consideration that can be proved in the court of law. This consideration should be something in return. For example, you go to the shop, you buy something, and you say, give me this product, and then you pay the price for that. Price is consideration. So in the business world, We all know that you will have to pay some consideration. There has to be a consideration for a contract to be considered as a valid contract. That means, is charity just when you want to give it for charity or voluntary services? Is it a valid consideration? Or something that you want to give away free, is it valid in nature? Let's see later on. So under common law, that is, the English law, UK, Australia, except in certain circumstances for an agreement to be binding, the offeree, that is to whom you have already offered to do something, or promisee, the other person, must provide consideration, which must be in the form of payment or of a legally sufficient value. Promisee. If you offer to purchase something, okay, for a consideration, the other person promises to deliver the goods to you. So he becomes a promisee. Or you say that I'll deliver the goods, I will purchase the goods to you and I will pay you a consideration. So I promise you that I will pay you the price for the goods. So I'm promising, okay, I'll pay you the price. Are you understanding? So therefore, this is a simple, a short transaction. Therefore, a offeree or the promisee must provide consideration, which may be in the form of payment or of a legally sufficient value. What is legally sufficient value? There are cases where the court said that you give something in return. I'm not talking about the barter system, but you give something in return. It should be of legally sufficient value, and that is enough valid consideration. We will see later on, there are cases. So it revolves around the principle of quid pro quo, a Latin maxim, which literally means something for something. That means you give something and something you get in return. That implies something in return is necessitated. So accordingly, gratuitous promises are generally not enforceable. Generally not enforceable. Gratuitous promises, that means it's like a gift. You give something away just freely. So gratuitous promises are generally not enforceable. So according to Blackstone, consideration is a recompense given by the party contracting to the other. So this is the definition. So if a question comes to you, explain the concept of consideration or define consideration or past consideration is no consideration. Always every answer should begin with the definition. What is that consideration? What is the value of that consideration? How valid is that consideration? So you'll have to put even the elements of valid consideration. So Blackstone, according to Blackstone, consideration is a recompense given by the party contracting to the other. Now, the Indian Contract Act now used this definition just to give you, an overall picture, because this definition is a little bit, in detail, just to understand what is this consideration. So the Indian Contract Act under Section 2D defines consideration as when the desire of the promiser, when at the desire of the promiser, the promisee or any other person, the one who promises is the promiser, the one who is at the other end is the promisee, or any other person has done or abstained from doing something, does or abstains from doing something, or promises to do or to abstain from doing something, then such an abstinence or promise can be considered as a consideration from the promise. To do something or not to do something. Abstain is not to do something or not to do something, whatever it is. That is in support of an agreement. To do something in return is a consideration. It operates around the principle of quid pro quo. So in the English case of Curie versus Missa, the court, there was Justice Lush there, he held that consideration, now this also is a definition, must consider either in some right, interest, profit, or benefit accruing to the other party, or some forbearance, detriment, loss, or responsibility. given, suffered, or undertaken by the other. So something has to be in return. He said it in, it is at page 162 of the judgment. Thus, there can be no legal contract unless there is a consideration in the form of a benefit gained or detriment suffered arrangement by the parties. Now, in the American case of Anshed versus Simnasha, this was actually decided by the New York Supreme Court. Here, the Supreme Court observed, that is the New York Supreme Court observed, that the law is well settled that in order for a promise to be enforceable as a contract, the promise must be supported by a valid consideration. Okay? Or offer plus acceptance, offer. It has to be supported by a valid consideration. So the essence of consideration is a legal detriment that has been bargained for in exchange for the promise in that particular case. And in short, the detriment must include the promise. So what they said here, Justice Lush says in the previous case, in Curie's case, he says that it could, consideration could be an interest, profit, benefit accruing to the other, or some forbearance, or even it includes detriment, loss, or responsibility given, suffered, or undertaken by the other. So anything can form a consideration, something in return. You'll understand. Let us go through the other slides. Wow, it got stuck up. Okay. So this is what was held in the American case. Next, let's move on to next slide. So here, there are certain essential elements of consideration. One, consideration can be in the form of payment or something of legal value. In Chappell versus Nestle, the House of Lords, an English case again, held that chocolate wrappers could be considered as consideration. I'm repeating, chocolate wrappers could be considered as a consideration. So for the purpose of consideration here, the courts are not interested in the adequacy of the consideration, whether the consideration is adequate or inadequate. It is enough or not enough. Are you understanding me? Consideration, for example, somebody decides to sell you a gold jewelry for, how to say it, say $1. You will not get for $1 a gold jewelry. You understand? So the adequacy, how much is the cost of it doesn't matter, but there has to be a consideration. A consideration can be even inadequate. So there has to be something in return. That is a consideration. That consideration may be in the form of payment or something of legal value. Adequacy is not a question. So all that matters is the promise or the performance provides some benefits to the other party or imposes some detriment on the promising or performing party. So Lord Somerville substantiated the concept of consideration and said at page 114 of the judgment, a contracting party can stipulate what consideration he chooses. Now, a peppercorn, I'm sure you know what's pepper. Peppercorn, it's a spice. A peppercorn does not cease to be good consideration if it is established that the promisee does not like pepper and will throw away the corn. So it does not matter. So consideration can be anything of value and that which is not illegal. Example, A promises to sell his laptop to B. If B arranges drugs from his friend to be passed to A. Now, this is an illegal promise and illegal consideration. He says, okay, you give me your laptop and for that I will arrange, drugs for my friend. Or A tells to B, I'll give you my laptop. For that, you will have to arrange, drugs from your friend. So laptop is kind of a consideration here. I'll give you this, you give me drugs through your friend. So this is an illegal promise, illegal consideration. Now, example 2, A promises to sell his laptop for, say, to B for $200. Here, $200 is a valid consideration. Now, consideration need not be monetarily adequate. Just like I said earlier, someone wants to sell you their gold jewelry just for $1. So the value is not the question here. Adequacy is not the question, but there is something in return. In Thomas versus Thomas, consideration means, the court said that, consideration means something which is of some value in the eyes of law. Economic adequacy is not significant. Next is consideration must be as per the demand of the offerer. The offerer says, I'll give you something for this price. Consideration must be provided by the offeree as demanded by the offerer. Now, actually in India, it doesn't matter who furnishes it, but this is English law. Consideration must be provided by the offeree as demanded by the offerer. A promises to sell his horse to B for $90. So he's offering to sell it for $90. He is proposing to sell it for $90. That proposal has to be accepted by B. But he's willing to purchase it for $90. The offeree has to accept it. He has to accept to pay the consideration, and consideration moves from the offeree to the offerer. It can move even from the promisee to the promiser, depending upon the transaction and what it is. So consideration must be real, not illusory, and be capable of being executed. I mean, it should not be imaginary. It should be real. It should not be imaginary. It should not be illusory. And it should be capable of being executed. For example, A persuades D to marry him and promises her the moon. It's not possible. It's illusory. So consideration must be real, not illusory. Now, consideration may be categorized as follows. Can you hear me?
Yeah, follow you.
Okay, thank you. So consideration may be categorized as follows. Consideration may be past, present, or future. Consideration may be executory or executed. It's very easy. It's very simple. Okay. Now, what is past consideration? You know what is past means something that is already taken place, something which has already happened, something which is, something that has already happened before. So that is past. Now, past consideration is no consideration. This is English law. I'm repeating. If you hear me carefully, you will surely understand. Past consideration